discretion to decide to keep your property. It can be forfeited to the state. Now, what we have in that scenario, where you have been charged administratively, is that we have the state effectively taking control of your property for an unlimited period of time, never reporting it to a court, no limits on the amount of seizure, very gray area for the reasons for the seizure, and your property can actually be forfeited to the state without any court supervision. So what we have is we actually have a joining of the executive power and the judicial power in that context. So when I'm reviewing this act and I'm looking at it and I'm seeing that basically we have moved away from what I call the rule of law, it raised the question in my mind is, are we in a situation in Canada today where consumer products are creating such a risk that we have to abandon significant procedural safeguards, that we need to move away from the rule of law? Because there are some things in this act, and you won't hear me say that I have a concern about tightening up consumer legislation. You won't hear me say that there aren't some positives on this act. But the question I have is well, let's say we want, to have, a reporting system or better tracking systems and things like that so that we could actually address some legitimate safety concerns. Can we not do those things in a way that actually enables us to still uphold as actually significant the rule of law? I mean, you will not find a political philosopher who will say that it's actually safe to allow the police to become the decision maker when it comes to seizure of property. So actually, I'm reading the act, and I have to tell you personally, I was just terrified that this creates a significant precedent of the move away from the rule of law, which makes me feel very insecure. I would discourage my children very strongly from ever going into selling or manufacturing consumer goods, because I know that they're in a situation where basically the state can be both the police and the judge. So am I out of time?
Just about.
Oh, okay.
Another minute.
The only other thing that I would want to address is extremely significant, is this abolition of the rule of trespass. I find it absolutely amazing that, the RCMP or OPP or municipal police investigating very serious matters can't come onto our property. If we tell them to leave and they don't leave, they can be charged criminally, they can be sued civilly, that we have so cherished our right to private enjoyment of property, we won't allow the police to do it, but we will absolve Health Canada inspectors from going onto our property without a warrant, without being invited. If they're told to leave, they can be on our property and not even be investigating us. They can be investigating somebody else. And it raised the question in my mind, again, are consumer products posing such a risk to Canadians that we cannot ensure consumer safety without abolishing the law of trespass? Because it sets a dangerous precedent. If it starts here for Health Canada, then what prevents another bureaucracy from going to the government and introducing legislation saying, well, we need to have the same powers. We're also dealing with significant things. So approaching this from a legal philosophical perspective, I have to say that the precedent that this bill represents is very troubling, and ironically, it's a safety bill. But we also have to consider whether or not it's in the long-term interests of Canadians to be moving away from fundamental legal principles that we've all been taught are extremely important for our liberty and our safety.
I sense you have more to tell us, but I think we'll flesh it out in
I could go on for hours. So
yes. We'll flesh it out in the question and dialogue period.
Thank you.
Cindy Cherniak.
Thank you very much. My first comment is a basic premise is in trade law, you've got good protectionism and you've got bad protectionism. And Bill C6 clearly has some good trade protectionism in that the aim of the bill is to protect Canadian consumers from harm caused by goods. So that is good protectionism. It's a good thing to do. And none of my comments are intended to detract from the good potential of the bill. But the ability for the Canadian government to prohibit a manufacturer by Canadian manufacturers or importers from selling creates some concern. The question is whether or not Bill C-6, in its current form and language, opens the potential for bad protectionism. Do we have the balance correct in this bill? And bad protectionism is protecting Canadian manufacturers from foreign competition. Bad protectionism is technical barriers to trade. Bad protectionism is disguised restrictions to keep a wall up at the border so that foreign goods can't get into Canada. Also, bad protectionism is putting a wall at the border so Canadian manufacturers don't offshore some of their production. So it's a two-way street. And probably this is how my comments may get a little unpopular. I'm not here on behalf of any client. I'm not here on behalf of any international organization or NGO. I was asked to come and comment because I am a trade lawyer and a trade professor and a consultant to the Asian Development Bank, and I've actually looked at 100 free trade agreements in my spare time. As Bill C-6 is written, I don't see any intention to breach Canada's international obligations, so I want to stress that as it's written, I don't see it as intending on doing something in particular when I read the language. However, the question I have is whether there is sufficient guidance in the bill or whether or not it's too broad, the powers are too broad, so that we can venture into the bad protectionism. And that's really, what I'm here to talk about. And I'm bringing 5 problems, even though there are more. I don't want to go on and on, so I'm going to address 5 issues that I see. When I look at sections 5 to 8 of Bill C-6, I ask whether or not it can be justified used to justify an importation ban so that foreign goods are kept out in order to protect Canadian manufacturers. Paragraph 7 sub A will allow an importation ban if an inspector determines that a consumer product is a danger to human health or safety. And there's a similar provision in paragraph 8A with respect to retailers advertising and selling a consumer product that they know is a danger to consumer human health and safety. And while there is a definition of danger to human health or safety in the proposed law, there are no clear rules. I don't know what that means, and I won't be able to advise foreign clients as to what that means and when someone will come to that determination. So is it possible for this to be misused? Is it possible for me as a lawyer to have a new area of practice whereby I go to the Canadian government officials on behalf of domestic manufacturers and say, I think these goods are of lower quality, they're a danger to Canadians, so you need to investigate and stop them at the border. And when I look at what's going on in some foreign jurisdictions, I've seen that happen in foreign jurisdictions with respect to goods getting stopped at the border, and hence we have WTO cases. Not necessarily on this basis, but there is a fear right now, especially, all this Buy America talk. There are a number of protectionist measures going up in place around the world. And it's possible we'll react in fear without science or clear justification for our fear. It's possible that we'll go offside what's called the precautionary principle in international law. And it's also possible that we're going to be stopping Canadian goods from coming in when they're manufactured offshore so that a manufacturer can be more competitive in the Canadian environment. So when I talk about what if Canada was looking at a foreign jurisdiction, one of our trading partners who were going to pass this law, and would we have concerns if the shoe was on the other foot, so to speak, and that Canadian manufacturers who want to get into a foreign market can have their goods stopped at someone else's border? What if our bill gets adopted by some of our trading partners as the precedent? And could this type of bill be used against Canadians? We're supposed to lead the way. And if leading the way may cause harm to our people, if we see that potential, should we not be looking at it from the perspective of our trading partners as well? So the bill adds business risk, and business risk was already discussed by Mr. Buckley, so I won't go on. But when you've got business risk, not all business risk is bad, but you need to have clear rules where you have business risk for both the Canadian businesses and foreign businesses, because we do need some of the foreign